Conrad is ready. Mr. Conrad Daly, Senior Counsel, Human Development and Technology, Legal Vice Presidency, Operations Policy Unit, the World Bank.
Thank you.
Over to you. Get the lady to us. Thank you.
Thank you. Well, is that too loud? No? Good? Yay? Wonderful. Bonjour, bon dia, good day, tafalcha more for those who speak Irish. You're all very welcome. First, my name is Conrad Daly. I'm Senior Counsel for Human Development and Technology at the World Bank. And first, thank you to Joseph and his team for having orchestrated an amazing and wonderful event. And thank you all for staying here so long. This is the third, and for some of you, fourth day at the end of the day. But we've saved the best for last, even if I do say so myself, as we look to the role of the legal framework in supporting these identification efforts. Not only that, you have two moderators, so we're going to try to spice it up a little bit. I'll be doing the co-moderating with my colleague, Nye Constantine. Let me give you quickly a short roadmap of where we're going. We're going to break it up a little bit and try to come up with a degree of fluidity. First, let me start by saying what this session is not about. It is not about legal identity. Legal identity is a fabulous, fascinating, and extremely important discussion, as we heard in the last session and as we've heard many a time. It is topic adjacent, or at least a sub-aspect of this conversation, so please bear that in mind while asking your questions. That's not to diminish its relevance, just to put it in context. So what are we talking about? This is about identification, or access to identification, and the right thereof. In civil law pedagogy, we will approach this in a three-part session, breaking it up with the third portion, the third paragraph, if you will, informing and opening up to a larger conversation with the rest of the panelists. The first section will look at the enabling environment. Essentially, it will look to how do we, the states, deal with states where they are looking to accord access to services, and in so doing, realize that they need to give a unique identifier and do so on a universal basis, therein opening up the access to identification. We'll then switch over to the safeguards piece with a particular focus on data protection. This will be moderated by Nye. And in doing the opening up, we'll look here to how the people and the systems are protected, and of course the data within. Finally, we'll come to the third of our sub-panels, and that will look at the consultative process, so having opened up access to identification, having worked to create the trust and facilitation thereof, of understanding what is going on, we will now say to the population, what is it that you need? What do you understand? We will make the legal reforms, and then we will go back to the population and say, and sensitize them to what is being done. All this within the understanding that law is anthropology, and if it's not alive, it won't work. So with that, let me go ahead and invite the first of our panelists up for S1, for the first subsection, please. So would the three physical people please join us? Madame Khadija Bamba from Côte d'Ivoire. Madame Bamba is the Director of Affiliation for CNAM, the National Health Insurance Fund in Côte d'Ivoire, and ID for Africa Deputy Ambassador. Josephine Mukesha, Director General from the National Identification Agency, NIDA. If you want to take the first seat, merci. Edson Guyai. Hello, Josephine, please. Director, ID Management at the National Identification Agency Authority, NIDA, and also ID for Africa Ambassador from Tanzania. Thank you. and I will join them, and what we will do is progressively add to the panel until we span the entire stage, and we will progressively move by the stages of the staging, and then open up to a first panel discussion amongst us. But feel free to start writing down your questions and sending them in, because after those two pieces, we will engage in a general Q&A with all of you. All right. Je vais commencer en français avec Madame Bamba. Donc, Madame Bamba, vous travaillez avec SINAM, avec le besoin de donner couvrage médical universel à tout le monde dans le Côte d'Ivoire. Donc, c'est avec ça qu'il y avait besoin de donner une identité unique à tout le monde, peu importe leur statut juridique, peu importe tous les autres éléments, mais pour assurer accès à ces services. Il y avait une loi qui gérait ça, et maintenant, vous et avec SINAM, est en train de mettre ça en place avec aussi un partenariat pour étendre le champ, pour donner une identité unique à toute la population. Donc peut-être vous pouvez nous dire des détails ou des données sur ça, sur comment c'était évolué et où on est et où vous voudrez aller. Merci.
Merci, M. Conrad. Bonsoir à tous. Et effectivement, au niveau de la Côte d'Ivoire, nous sommes dans une identification pour la mise en œuvre de la couverture maladie universelle. C'est quoi la CMU? La couverture maladie universelle, c'est un mécanisme généralisé de protection contre le risque maladie. C'est un système obligatoire et il a été mis en place par une loi. Donc il y a une loi qui a été votée en 2014, en mars 2014, pour instituer la couverture maladie universelle en Côte d'Ivoire. L'objectif, c'est de permettre à toutes les personnes qui vivent sur le territoire ivoirien d'avoir accès à des soins de santé de qualité. Mais toutes les personnes, quelle que soit leur nationalité. Donc quand vous êtes résident, que vous soyez ivoirien ou pas, vous avez l'obligation d'être à la couverture maladie universelle. Pourquoi est-ce qu'il y a une identification qui a été confiée à la CNAM qui gère donc cet instrument, la couverture maladie universelle? Parce qu'au démarrage, en 2014, ce qu'on avait constaté, c'est que pour les assurances privées qui existaient déjà, on avait beaucoup d'abus dans l'utilisation de ces prestations. Des personnes utilisaient des actes avec des documents qui ne leur appartenaient pas forcément. Ça, c'est la première cause. La deuxième, c'est que à ce moment-là, on n'avait pas un identifiant qui prenait en compte toutes les personnes qui vivent sur le territoire ivoirien. Donc, on avait des identifiants, mais qui étaient adressés à des groupes spécifiques de population. Donc, l'État a autorisé la CNAM à collecter les données à travers un décret. Donc, il y a un décret qui autorise la CNAM à collecter les données, un décret sur le traitement des données à caractère personnel qui s'appuie sur une loi qui a été citée ce matin par Madame la parlementaire. Cette loi, elle existe depuis 2013 et c'est sur cette loi-là sur la base de cette loi que le décret a été pris pour autoriser la Caisse nationale d'assurance maladie à collecter les données. Comment se fait cet enrôlement? C'est de la collecte de données biographiques, mais également biométriques. Donc, on prend la photo, on prend les empreintes des personnes qui viennent sur les sites d'enrôlement et après, on leur donne un identifiant, un numéro d'immatriculation. Et la loi qui institue la CMU prévoit que cet identifiant soit le niveau de sécurité sociale au niveau de toutes les institutions de prévoyance sociale en Côte d'Ivoire. Donc, que ce soit les structures qui gèrent la retraite, les accidents de travail, maladies professionnelles, la maternité, les prestations familiales et même la santé, puisque avant la CNAM, on avait des entités privées qui géraient déjà l'assurance maladie. Donc, toutes ces structures-là ont l'obligation d'utiliser l'identifiant unique qui est produit par la CNAM pour les prestations qu'elle gère. Donc, c'est un identifiant à 13 caractères qui est donné à ces personnes-là qui sont enrôlées à la couverture maladie universelle. Et l'identification va se matérialiser par une carte qui est donnée donc aux populations. Et pendant l'accès à la prestation, M. Conrad l'a dit, il s'agit ici d'une identification pour avoir accès à une prestation. Donc pendant l'accès à la prestation dans l'établissement sanitaire, et on a des appareils qui sont installés, des lecteurs de cartes biométriques qui sont installés et qui permettent de vérifier, d'abord d'authentifier la carte qui est présentée, de se rassurer que la personne qui est en face est effectivement celle qui est propriétaire de la carte, et puis enfin de contrôler les droits, parce qu'on est dans un mécanisme assurantiel dans lequel on a l'identification d'accord, mais on doit payer des cotisations avant d'avoir accès à la prestation. C'est vrai qu'en Côte d'Ivoire, on a une partie de la population qui ne peut pas payer des cotisations comme partout ailleurs, qui est couverte par l'État de Côte d'Ivoire. L'État paye leurs cotisations, mais c'est un mécanisme assurantiel. Et donc, à ce titre, on contrôle également les droits quand on est à l'hôpital. Aujourd'hui, on a beaucoup avancé dans ce dispositif. Je parle de 2014, donc ça fait pratiquement 10 ans que nous sommes dans ce processus. On a connu des difficultés et l'année dernière, on a mené une grosse opération de masse qui nous a permis d'enrôler en 6 mois plus de 5 700 000 personnes. Et aujourd'hui, la CNAM compte dans sa base 13 millions de personnes. Donc environ 43% de la population est déjà enrôlée à la couverture maladie universelle. Nous bénéficions cette année et dans les 2 prochaines années de l'appui de la Banque mondiale pour poursuivre ces opérations d'enrôlement de masse et qui vont permettre d'avoir accès à d'autres services. Donc, avec cet accompagnement de la Banque mondiale, on ira au-delà des soins de santé, on aura d'autres prestations qui pourront être données, mais à partir de cette collecte-là qui est faite aujourd'hui par la Caisse nationale d'assurance maladie dans le cadre de la couverture maladie universelle. Monsieur Conrad, voilà un peu rapidement ce que nous faisons au niveau de la CNAM en Côte d'Ivoire. Merci.
Merci bien, Madame Bamba, et très bien fait avec le timing, c'est vraiment impeccable. Donc, merci bien, ça commence avec un bon début. Josephine, how in your country, now we've heard, I know we have similar interests and similar aspects of concern, but how in Rwanda are there has that complemented? Have there been issues on age? And I think there may be more similarities as we move down the row, so to speak. But would you care to add in or give us your country's perspective and how you've experienced similar efforts to expand universal identity in the pursuit of other services that you've encountered? Thank you.
Thank you, Conrad. As my colleague just said, in Rwanda, we had the law on the issuance of identity and registration of population. The identity card was issued to citizens 16 and above, and it was issued to Rwandans, refugees, and foreign residents. And residency is defined by somebody who's going to have a resident permit from 6 months and above. But as we moved along, we found that the need is now to provide full access to the entire population, because those who are below 16 could not access seamlessly services that are provided today online. So to allow that, we did a feasibility study that recommended that our law needed to be amended, and we amended the law last year in 2023. Now we expanded the issuance of identity from birth, and this is based again on the change, also amendment of our law on civil registration that took registration from sector offices to the health facility. So it is like a one-stop center principle where we record the event where it happens. This has helped us a lot to ensure that we have now above 90% of birth in Rwanda that are registered within 3 days of their birth. And as such, we use the civil registration and population registry, because not all Rwandans are born in Rwanda, to provide the data to issue the identity card. And the identity card now, our single digital identity that is now in the process of being implemented, will be issued from 0 to death, from birth to death. And then we also expanded the coverage of who to give it to. So we are now going to provide the identity to Rwandans, foreign residents, but even a foreigner who's in Rwanda for a short period, because the identity allows access to services. We're also providing it to asylum seekers, because as you know, the process to receive and get the refugee status might be lengthy, and during that period, the people under that category were not identified. So we are going to issue the identity card even to the asylum seekers, foreign workers, migrant workers, because within the region we have a lot of people moving around, and they were not catered for in the existing laws. So we are going to provide identity to them, and even the stateless people, because we have people who, due to the border changes, found themselves in Rwanda, but their country of origin does not recognize them anymore as the citizen from that country. So we have the stateless as well. So all that now with a digital identity, we are planning to provide identity to the entire spectrum of people in Rwanda.
Wonderful. Thank you very much, Josephine. And likewise, thank you very much for respecting the time limit. And how's that for inclusivity with the efforts that are going on? Edson, also from NIDA, only from Tanzania, would you care to add on about similar efforts? And I know, again, it's been healthcare that's been an incentive in many ways to move your efforts along. Thank you.
Thank you, Conrad, for giving me the chance to share the Tanzanian perspective on the national ID. In Tanzania, we started the national ID project in 2011, but the national ID authority was established in 2008, and we have given mandate to register and issue identity credentials to 3 groups or 3 categories of person. Number 1, to issue credentials for the citizen. Number 2, for legal residents. And number 3, for refugees. And recently we have amended our regulation, and we have now accommodated stateless person. So at the moment, we are registering 4 categories: legal resident, citizen, stateless, and the refugees. If you look at the national ID for Tanzania, for us, we look at national ID as a tool for the social and economic development. The national ID, from the initial design, it was designed to be shared. It was a digital platform with the smart card technology. So from the inception, the national ID is designed to be shared. So up to date, we have managed to register 24 million and issue them with the identity credentials, and it's almost 94% of the adult population. Because our laws mandate us to register and issue ID credential to the persons of 18 years and above. Now it's come a new challenge, now a new problem where we exclude some of our population, the minors, the people with below 18 years. So because of the pushing demand from the financial inclusion angle, from the social protection, and from the health insurance cover, as my colleague has talked about. This push, because last year our government has passed universal health insurance, which mandate at least a person citizen and any person who resides in Tanzania to have at least a minimum health insurance cover. So this is a government initiative, but the challenge comes: how are you going to identify? How are you going to make sure these services are rendered to the required population? So understanding the capability of a digital platform, the national digital platform, the government has decided not to issue a health insurance card to citizens, rather than use the national ID card as health insurance card. So this, what is the advantage of this? The advantage is, first, we save cost, and also we avoid duplication of effort. Because if you issue health insurance card and national insurance card, you are issuing, or you are giving services of services to a single person, which it gives some complication in the implementation. So the government have decided to use the national ID cards as the health insurance card. The second thing is the social protection. Government is giving subsidies to marginalized peoples. We have the scheme where government provides subsidies on the input for agriculture, and also the subsidies to the marginalized and the poor person. So all these initiatives need a robust and a proper managed identity ecosystem. Up to now, we have managed to connect more than 100 institutions. This span from telecoms, financial inclusion, and all companies, private and public institutions which are rendering services to the people. Why are we encouraging to to integrate. We are trying to solve the challenge of identifying person, forgery, fraud. So this is, apart from improving the service delivery, we also enhance national security. Because the national ID has major two roles: enhancing the national security and also improve service delivery to our people. So we have, as the enabling ecosystem, environment for the national ID ecosystem, we have 4 major laws which act as the pillars for the Tanzanian national ID ecosystem. Number one, as I said, we have National Registration and Information Act, which gives us mandate for registration. The second one, we have an e-government act, which gives the standard. How are we going to share the information, the practice? This is number 2. Number 3, we have Data Protection Act. This is a new law enacted 2 years ago. But from the design, because we know that we are implementing digital ID, and there is a global data protection principles. So because we started in 2011 without data protection principles, but we managed to accommodate the data protection principles in our design. So the sharing of data, processing, and whatever we do in our national ID system, we are there with the Data Protection Act. This gives us the trust to the stakeholders, that government, privates, and also to the citizen. So this, for us, we have managed to gain trust.
Great.
To gain trust, and now we are doing the revision of law to include the people below 18 years and above. And also, we have gone further, not only revising the law, but also merging 2 institutions. Previous, the civil registration and the civil identification, it was done in different institutions, in different ministries. But now we are revising the law, and we are merging these 2 institutions to have a strong integration and a strong integration between the civil identification and the civil registration, so that we can manage and control the life cycle of a person. Thank you, Conrad.
Thank you very much, Edson. And that's a wonderful place to segue into our next panel. While the other panelists are coming up, if we could flip just briefly to the image with the speakers. We had, unfortunately, a 4th one who could not speak with us join us, Mohamed Ouzgan from Morocco. So while the second panel is coming up, I just want to add in that this panel, or excuse me, this individual was involved and is involved in Morocco's efforts, and I'm going to move down to leave the S2 come up so that our panelists are all closer, because I'll be coming in again at the end. But Morocco, and Monsieur Ouzgan is the chief lawyer. We have some of the Moroccan delegation here. One of the elements that was key to their efforts, and they're creating a unique foundational identifier. And on top of that, they're doing a social registry. One of the pieces they baked into their law from the very beginning was a data protection reference to the law that they already had in place. And from the beginning, they took a human rights approach, with Monsieur Ouzgan, amongst others, going directly to the king and making sure that this was an element that was respected. And with that, I will hand it over to Nai to introduce her panel and to bring in the safeguards piece with data protection at the forefront of it. Thank you.
Thank you so much, Conrad. Thanks for our esteemed panelists for a wonderful introduction of this long session, but we hope that it's going to be interesting for all of you. My name is Nai Constantine. I'm part of the World Bank's digital development team, more specifically the ID4D initiative. And I specialize as well in the legal enabling environment for digital transformation, but also more specifically digital ID projects. I'm very glad to be alongside excellent speakers and panelists in each in their respective roles. I'll start with Mrs. Immaculate Kasait, Data Commissioner of the Office of Data Protection in Kenya. Dr. Vincent Olatunji, National Commissioner and CEO of the Nigeria Data Protection Commission, and Mrs. Laura Bingham, Executive Director of the Institute for Law, Innovation and Technology at Temple University. Thank you for joining us today. And I'm sorry for turning my back on you, but I will have to look at them. So safeguards, data protection, privacy. I'm glad to be alongside the both of you, but also Laura, who has been really specializing in the questions related to privacy, human rights, fighting against discrimination in digital IT systems. These are all extremely important points. And I'll start perhaps with lessons learned from countries, perhaps with you, Commissioner Kasait. We all are quite familiar with Kenya's journey when it comes to data protection and digital ID. We know the state of the art under the Huduma system, but we also know that a transition is now envisioned. So could you perhaps tell us a bit more about Kenya's journey when it comes to data protection and what are the lessons learned and how are we embedding them as you think through the MISHA? I lost my mic, I think, sorry. As we think through the MISHA number.
Thank you, Nay, and I want to thank Joseph, Dr. Joseph and the team for putting together this panel and for the opportunity to put at the center data protection. It was not the case a few years ago, and we really do appreciate to have this platform. Nay, direct to your question, what are the lessons learned? I think some of those are PSUs in the audience for citizen services. Ambassador Professor B talked about them. And some of the key lessons from the Kenyan journey was one, resistance. And the resistance by the public was basically they were demanding, I think India had just gone through the journey of Aadhaar, and they were demanding an independent data protection authority. Mm-hmm. They were demanding to see a data protection impact assessment. They were demanding for transparency. Basically, the principles around data protection: transparency, accountability, public trust. And those were the lessons learned. And I often say it is through that process that we saw the birth of the Data Protection Act in 2019. Based on those demands, we see Kenya moving from the past experience to now towards Maisha Number, a more collaborative partnership with civil society, with the Office of the Data Commissioner. And some of the issues we've had is training for the officers who are dealing with Maisha Number. We've seen some of the lessons learned also, them moving away to upholding equality and inclusivity. And that has been an issue which even the PS talked about, removing the issue of vetting, because there was a lot of issues around why are we being discriminated against. Upholding privacy concerns, that is the other one. We've seen in the Act, it's very specific in terms of Data Protection Act, what privacy concerns are there, the principles, the lawful basis for processing data. So you're seeing them taking that into account. The other one is we've seen an adoption of guardrails and safeguards. And of course, from an office perspective also, the lessons learned, you had the first issue around data protection impact assessment. From an office perspective, we've been able to also issue advisories in as far as data protection is concerned. And on that, I mean, we say give flowers where they are due. One of the most responsive government department is actually Interior. We've seen over 8 advisors seeking, yes, and that is under PSB talk. You've seen them seeking actively
privacy impact assessment
to actually be trained to actually seek advisory on the data protection impact assessment. And at times, because we are not very many, even we get overwhelmed because they want to be on the right path. And that shows they are going out of their way to actually take into account the lessons learned from the previous, what happened in the previous
Do you think
Huduma.
the decision, the judicial decision, impacted in this?
Sorry?
Do you think that
Yes, it did.
Yeah.
I think there were no people who learned the bitter lesson of data protection more. Because I mean, they were right there, and Kenyans are quite litigious. If you want case law on digital ID, please come to Kenya. We have a lot and tons of volumes of information in as far as this is concerned. From a regulatory perspective, based on the lessons learned from Maisha, one of the other thing we've done is we are in the process of the audit, because part of the regulatory frameworks expects us to actually do an audit of civil registration. The other one is of course, the advisories that we have issued. I like to say that we are not there in terms of data protection, but there's effort. 3-4 years ago, there wasn't much spoken about data protection. As we speak, cumulatively, we've had to do 164 advisories on data protection. On that, in the last year alone, we've had to do 47 assessments on data protection impact assessment. It shows an interest, it shows a country where people are paying attention about their rights. And as I conclude, the other issue we've seen increase in terms of public participation. And for us, I say, I don't think many people have actually realized, and it's important because we are speaking to people in the space of digital ID. I don't have proprietary rights to the phrase, who moved my cheese, but I can say the cheese moved. We really are in an era where the personal dignity has been taken, people have taken back their personal dignity in terms of rights and privacy. It's important for us to reflect, even as we do public participation, what this means and what these fundamental rights of privacy. Maybe when we passed it, it sounded like a cliche, but now it's a reality. That people, when it comes to matters around digital ID and therefore issues around data protection, personal privacy becomes a fundamental issue. I think I'll stop there on those 8 high-level concerns.
You're perfect on the
in
timing.
terms of that. Thank you.
And perfect on the response. Thank you so much. Speaking of data protection becoming a reality and a raising topic, Dr. Vincent, what is Nigeria's journey? We know it has been a long journey for the data protection law. What are the lessons learned there, and how do you collaborate with the digital ID authorities?
Thank you very much. Good evening, everybody. And would like to first thank the organizers of this conference for inviting Nigeria as a country to share experience, especially in the area of data privacy and protection. From the conversations since the last 2-3 days, it's obvious that everything that we're talking about is about digital economy, global digital economy, and the close relationship between a digital economy and digital identity. In fact, the foundation to any digital economy is your digital identity. The next question is, how do you now ensure trust and confidence in your digital economy? And in Nigeria, we realized this, and that was why we've been putting a lot of measures in place, laws, policies, to enhance what we can put in place to drive a digital economy for us to be globally competitive. The digital economy sector in Nigeria, about 20 years ago, was contributing just about 4% to the economy, more importantly in the telecom sector. But because of a lot of policies that government has put in place, as we speak, we have contributed about 18.4% to our GDP in the country. Now, the next thing is, how do you ensure trust? And how do you guarantee trust in whatever we are doing in the digital economy? And that speaks to the fact that we need to protect the identity of our citizens. We need to enhance their freedom, their interest in whatever they do, and at any point they share their information. In fact, the foundation is actually in the Constitution of 1999, as amended. Then there have been several acts of parliament speaking to the issues around data privacy and protection. But nothing concrete was really done until in 2019, when a regulation was issued on data protection in Nigeria. And to ensure that we properly position the issues of data privacy, a committee was set up to ensure implementation of the regulation. That was under the IT Development Agency in Nigeria then. With the work of the committee within 1 year, we made a recommendation to the former president that the global trend more importantly, we are going digital in everything, was for us to have a principal legislation on data protection and have an independent data protection authority. Now, the question we asked ourselves then was, would that be a data protection authority without a law setting it up? Or should we have a law without a data protection authority? Because we are really in a hurry to catch up with what was happening in the rest of in the other parts of the world. More importantly, with the ECOWAS Submit Act of 2010 and the Malabo Convention that a lot of people have spoken about of 2014 on cybersecurity and data protection. So the former president issued a directive that a bureau should be set up to oversee the implementation of issues around data privacy in Nigeria. And that was where the Data Protection Bureau in Nigeria was set up in 2022. One of the mandates of the Bureau was to ensure that we developed a principal legislation on data privacy and protection in Nigeria. And we were able to work with a lot of development partners. Within 9 months, we were able to put up a law. And one thing that really worked for us was the fact that we actually engaged all stakeholders, even at the drafting stage. We tried to workshop the draft law with them. So by the time we got to the Federal Executive Council, that was the highest ruling body in the country, where you had the president as the chair and the ministers, about 40 ministers also seated. We made a presentation to them, and that was on the 25th of January 2023. The presentation was adopted as a national policy, and from there it moved to the parliament. And we have bicameral legislation in Nigeria, the upper legislature and the lower house. It was the executive bill from the president was approved within 1 month, which is really unprecedented in the affairs of passing laws in the country, because we are already involved in right from the beginning. So they probably understood what we're trying to do. So within 1 month, the Senate and the House of Rep passed the concurrent bill, which was sent to the former president. It got to him on the 26th of May. He was to leave on the 29th. Fortunately and unfortunately, he couldn't sign before he left. So when the new government came in, we really felt bad that the former president couldn't sign. But one good thing that has really worked for us as a country, as a commission, and in the area of data privacy in the country, was the fact that the new president, when he came in within 12 days of coming to office, he signed the Nigeria Data Protection Act on the 12th of June 2023. With that, we now have more credibility in the present government. So we transitioned from one government to the other. And that speaks to the approach that government has given to, and the attention that government has given to data privacy and protection in Nigeria. Now coming to implementation, looking at the size of the country, a country of over 220 million people, we are talking of 774 local governments, about over 928,000 square kilometers of land mass. How do we, a small office that is just coming up, now properly deepen data privacy and protection in the country? With my background as a PPP strategist, we adopted a PPP model where we licensed experts in data privacy and protection to offer compliance as a service. So this, we'll be able to achieve a lot of traction through our engagement with private sector organizations who now see a complete different economy being created through data privacy and protection. And with that, we'll be able to, we actually started our own audit returns immediately because of the partnership that we had with the private sector. When we started, it was very low because the awareness was very low in the country there. The first audit return we had was about 632. But last year, we've risen to over 3,000. But the question is, are we really there? No. We are talking of about over 500,000 data controllers and processors that we refer to as data controllers and processors of major importance in Nigeria that must register with the Commission and also file their annual audit. If we are doing 3,000, that means there's still a lot of work for us to do. But in the public sector, it's more difficult to actually implement the law. It says that a lot of public sector organizations say, oh, this is my job, this is my mandate, you cannot come and tell me what to do. But our approach has been partnership collaboration and cooperation with them. And that was why when the law was passed, the strategic roadmap that we developed, collaboration and cooperation is a major pillar to work with regulators in different sectors in the public sector. And we're able to obtain a circular from the Office of the Secretary to the Government, that's the office that coordinates the activities of the federal government, that all MDAs must comply with the provisions of the law. When we started, compliance with policy was just 4%. As of last year, we were doing 15%.
Dr.
And
Vincent, I will have to interrupt you because we will need to wrap up so that I can give Laura a bit of time. No, please finish your point if you can just wrap it up. I just want to make sure that I'm on time because I know that the other speakers also. So collaboration was
Collaboration
very important.
is really key, which is work with regulators from different sectors. Because for each sector, as a data privacy expert, you don't really deeply understand what they do in this sector, the kind of data they collect in that sector. For instance, what we do in net, which is sensitive, is different from education, different from aviation and tourism, for instance. So we need to work with each sector
on
to
it.
even to develop sectoral guidelines. Like the parameters we review, we evaluate when we are carrying out audits about 67. Whereas in some sectors, they must not need more than 25 for them to check and do their proper audit. So these are the things that we are trying to do. But one thing that is really important that we have adopted as well is PPP and collaboration with different organizations and even civil society groups. And we are not afraid of criticism. Please, when you are setting up your law, you are setting up a commission, don't be afraid of feedback from people. Even negative feedback will definitely assist you in whatever you are doing. Thank you.
Thank you so much. Speaking of feedback and the importance of collaboration, let's talk to academics and researchers represented by Laura here. Laura, in one of your pieces, you spoke about the importance of being very careful with biometrics and their use in the digital ID system. So what do you think you would recommend policymakers, decision makers to think about as they design their systems and leverage biometrics in terms of safeguards and guardrails?
Thank you. Okay, so, and I realize we're running short on time because there's actually a clock up here that says I have 24 seconds. I thought I would just start by saying a few words about why I'm here, on what basis I sort of have any authority to be speaking on these issues. And in addition, I am an academic. I sit at a university in the United States, Temple University, but previously for about 15 years, and I'm a nationality and migration and discrimination lawyer, and I worked quite a bit in Kenya and other countries in Sub-Saharan Africa, Latin America, and Asia on really identity, bureaucracy issues, pre and post digitalization and during. I also work with a coalition of about 50 civil society organizations. So most of my work has really been with civil society as an international human rights lawyer. I've engaged in cases in the regional bodies in Africa, especially I'd like to mention one case in particular, which was to the African Committee of Experts on the Rights and Welfare of the Child on behalf of Nubian children in Kenya, that resulted in a really landmark decision that linked access to birth registration to resolving, hopefully, situations of statelessness. And so I'm wading a little bit into the waters of legal identity here. But I think that's really necessary. And I just, on the point about discrimination, I think it's much broader than the issue around biometrics and bias, although that's obviously of a great concern, and I know a lot of people here are working to address it. But when I think about discrimination and digital ID systems and trying to reach as many people as possible, I think the key thing, just to throw back to the panel we heard from earlier, just the last panel of civil society actors, is that you really have to dismantle discrimination in any system that is built to be universal in its application. You have to work from facts, you have to work from evidence, you have to do the research and understand the structures of how discrimination functions in society. And that the really key thing is to go to the impacted people. And I think we're talking about processes and procedures and capabilities that are being built within a lot of different institutions, including data protection commissions, to reach out, to do public participation, to increase engagement across a lot of different mechanisms. But there really is no substitute in going and hearing from people who are impacted by discriminatory structures. And sometimes those have nothing to do, most of the time that really doesn't have anything to do with the data protection law itself. It does have to do with laws that relate to legal status, for example, even constitutional structures. But the key thing is not to approach those individuals and groups to explain the solution that you have in mind, or to help them better understand how biometrics functions. The point is to understand how is discrimination really working? What are the legal and practical vectors that are bringing that about? And what solutions are needed from the point of view of the impacted groups? So I think that's a point that was made quite well in the last panel repeatedly, but it really bears on this discussion that we're having here and the question that you asked about even a biometric system, even when we are sort of nominally saying, well, this isn't about status, I think if you put the cart before the horse and you don't really grasp those issues or look into them, that's a lesson you're going to have to learn down the road. I also just wanted to quickly, if I have a minute, share another sort of part of this community that I participate in is the Digital Public Infrastructure Safeguards Framework. I'm part of one of the working groups, and that was explained yesterday and also spoken about a little bit today by colleagues from UNDP and the Office of the Special Envoy on Technology to the Secretary General. I'm in the working group that's looking at operationalization. And so I just wanted to make, and that means operationalization of, again, really ambitious society-wide technological infrastructure projects. What does it mean to operationalize individual rights frameworks and safeguards? So I think one key point that keeps coming up is around access to justice and the rule of law. And I heard a couple of other panelists talking about courts and judiciaries and the need to include judicial actors. I wanted to just re-emphasize that. I think that's such a key part of thinking about capacity building. And if there isn't really an access to a remedy, ultimately a judicial remedy, for people who do encounter individual rights problems, then we're missing out on how to learn the lessons. We're missing out on the rule of law and the checks and balances that really need to be in place. But the justice sector is much broader than that, and I think it's also important to recognize that that civil society groups, legal service providers, they do such important work. It's very undercompensated, it's underfunded. But there's also a lot of people who are trying to understand and navigate these systems and see their value, but they don't have any assistance to help them. They're without access to legal aid if they need legal aid. This is the case in many, many, many societies. The other thing that I wanted to emphasize that has come up is that we also have freedom of information laws, right to information laws, in addition to DPIAs, which the commissioner spoke about, which I think are just incredible and so important to be done with detail to standards. We can talk about that more, I hope, if we have more time. But freedom of information laws, really there's a lot of scope to innovate on pushing information out, being more responsive to requests. I think the Slido here is a great example of how to put questions directly to people who are in positions to make policy or to make really important decisions. And that's how our freedom of information laws should be working around these systems as well. So I think that tends to be an overlooked, really key operationalization feature. I'm going to stop there.
Thank you. That was great because you reminded us to look at it from an ecosystem perspective and not only focus on the technology itself, but on the overall ecosystem of digital identity and include due process and access to justice, but also access to information. Conrad, I just want to check in on time and how we're doing with the rest of the panelists.
We're a little short, but we unfortunately only have two, so to speak. fortunately only in the sense that we have time limits constraints. So maybe let's pull the 2 for the session 3 up, and then we'll open it up to a panel discussion.
Sounds good. Over
Thank
to
you.
Thank you so much, the 3 of you.
Thank you very much, Nai, and everybody so far. We have 2 fascinating discussions coming up, and I think Laura staged it nicely. All of our panelists have, but I think talking about discrimination, we're in a very good space here to talk about how that can be combated and how that can be worked with. We have from South Africa here, Thulani Mavusu, who is the Director General of Institutional Planning and Support in the Department of Home Affairs, and Dr. Jean Uhulu, Coordinator for the Wuri Project, National Agency for the Identification of Persons, ANIP, in Benin. And I think with this question about discrimination, with the question of how do you understand your population, it opens up and it carries on the conversation where we started with, you want to give a service, you want to open it up, identification, you need to protect the people and the services and the systems, but just putting out the systems isn't enough. Just making the changes in the law isn't enough. It's a consultative process. It's one where the populations need to be engaged, and it is an anthropological work into itself. So I think with this place, it's good to start with South Africa, and then we'll move into Jean's discussion on his experiences in Benin. Please, Thulani.
No, thank you very much for the opportunity to participate in the panel. I think on the issue of including citizens in particular in legislative making, it's quite an important activity, because in South Africa, for an example, in legislative making, we're making the point that whichever ministry that is trying to develop a new legislation, you've got to develop, for an example, a concept paper that goes for public consultation, because you've got to gazette that for public consultation. Once that concept paper has been approved by cabinet, then it will have to go to develop a green paper or a white paper, because a green paper at the time is not the official position of government. Once cabinet adopts that particular white paper, then it's an official position of government, where you can then start drafting the bill for introduction to Parliament. All these stages, they go with the consultative process that you've got to engage the public. Even Parliament itself, they hold a lot of public hearings if there's a bill that is being processed. So that's how you ensure that there's participation of members of the public, because if you don't do that, it means it undermines the democracy that you have created. I think we have done in the last few years quite a number of policy documents. For an example, we are reviewing our legislation on marriages. So we had a lot of interesting inputs that were made by members of the public. One of those was the issue of polyandry, because in society we've got a lot of polygamous marriages that are recognized in South Africa because of cultural beliefs. Also, you've got traditional authorities and things like that. So therefore, you put the legislation to enable that. So I think in these issues, it was therefore important that you get the voices of the public. You cannot just enact a legislation that does not have the participatory process. So also, I think one of the things that we also take into consideration now, we've got an official identification management policy, which is going to reform how we manage identity in South Africa. We have delayed in passing that particular legislation because one of the key issues we are looking at is how do we ensure that you create a legislation that is in line with digital age. Because if you don't do that, you'll find that you will have to review that particular legislation that you would have dealt with. So we are in the position, therefore, when we presented here on Tuesday, we raised the issue that we are currently developing a digital identity policy that will also inform how our new legislation on official identity management pans out. So I think for us it's quite important. We're also looking at other countries, what they've developed in ensuring that they have a legislation that is responsive with digital age. Because if you remember now, we've got a lot of online verification where we verify citizens' data. So there's a lot of information that is sitting in the cloud. So how do we ensure that the legislation is there to protect the citizens, but also enables us to do transactions that can be authenticated, non-reputation of those transactions. So there's a number of other areas that we are looking at, but it's quite an interesting space. We are ensuring that even our constitution supports this particular participative process that citizens get involved in when making legislation. Thank you very much.
Thank you very much. That was very interesting, and I think it ends nicely in the sense that the best enablers are safeguards, quite frankly, for the people, for the systems. Donc, on va revenir à la français, à la langage française, avec Jean Ohoulou from Benin. Jean, vous avez votre pays à bien avancé dans les réformes juridiques. Donc, j'aimerais bien voir ou entendre comment est-ce que le processus il a commencé avec les consultations avec le peuple, tout comme ici en Afrique du Sud. Et puis, il y avait des réformes juridiques qui étaient assez larges, assez substantielles et d'une certaine conséquence en soi. Comment est-ce que vous n'avez pas juste mis en place la loi, vous avez allé vers la population. Donc, j'aimerais bien entendre tout d'abord, brièvement, c'est quoi les changements, surtout parce que Laura et parmi les autres ont parlé de l'identité juridique ou légale. Il y avait des changements avec le RNPP. Si vous pouvez donner des résumés sur ces réformes et puis le processus de sensibilisation de la population pour qu'il fonctionne bien. Merci.
Merci. Merci pour cette préoccupation très essentielle en droit. Il faudrait avoir la loi, mais il faudrait aussi garantir les conditions de son effectivité. Et quand on parle de l'effectivité en droit, il fallait assurer d'abord, comme au préalable d'abord, les éléments de l'engagement en tant qu'un outil dédié à la participation de la population. Et là, comme point de départ au Bénin, nous nous sommes rassurés que d'abord, des difficultés partant des difficultés du passé. Ces difficultés liées à la mise en œuvre des projets de développement, on s'est rendu compte que le principal problème qui s'était posé à ces programmes de développement, c'est le problème de l'adressage. Et pour l'adressage, parce que ces différents programmes s'adressent à des individus, mais dont l'État a de difficultés à maîtriser. Et là, fort de ceci, nous avons mis en parallèle les différentes solutions du passé, les initiatives pour redresser la question de l'état civil. On s'était rendu compte que, fort des limites de ces différentes initiatives, il faudrait partir à la mise en place d'un système d'identification de base. Et pour y parvenir, il fallait s'enregistrer, s'inscrire dans un processus de dialogue social pour expliquer d'abord le bien fondé d'un système d'identification de base qui est différent des initiatives antérieures qui n'ont visé que la question liée à l'état civil. Ça veut dire qu'il fallait réinventer un système dans une approche globale qui vise à identifier toutes les personnes présentes suivant les différents statuts juridiques. Et là, pour y parvenir, vous ne pouvez que communiquer sur des éléments pouvant garantir le succès de l'opération. Et là, il fallait d'abord construire ce que nous avons appelé les éléments de langage. Parce que, ayant connu des différentes formes de recensement par le passé, il faudrait éviter quelques éléments qui vont induire les biais et constituer des obstacles à la mise en place de la nouvelle démarche. Je donne un élément par exemple, c'est qu'il fallait tout dire, sauf dire aux gens que le nouveau recensement allait les conduire à payer plus d'impôts. Et là, vous ne verrez personne. Alors, dans cette forme de dialogue social, nous avons constitué ce que nous avons appelé pour garantir cette forme de participation, le groupe-là que nous avons appelé les imprégnateurs, qui étaient chargés de dialoguer dans une forme de structuration, d'intermédiation sociale pour assurer les éléments garantissant la participation active de la population. Et une fois tout ceci était fait, fort de l'adoption de la loi 2017 portant identification des personnes en République du Bénin, à travers cette loi, l'État a engagé une rénovation, c'est-à-dire adresser uniquement à travers la loi la question d'identification, sans mélanger avec les autres formes, les autres prérequis, l'adressage de la question de l'état civil et autres. Et une fois cette loi adoptée encore, il fallait redescendre sur le terrain après la première phase d'explication pour la nécessité d'adressage de la question d'identification des personnes. Une fois la loi adoptée, redescendre sur le terrain encore, populariser cette loi pour leur dire les innovations clés que comporte cette loi. Et à travers ça, quels sont les biens fondés, quelles sont les finalités en termes d'attribution du numéro personnel d'identification, que peuvent procurer à l'individu l'adoption, la détention de cet identifiant unique. Ceci a pris des mois, tout un processus. Et pour pouvoir y parvenir, non seulement il faut hiérarchiser, il faut mettre plusieurs structures ensemble pour assurer cette nouvelle forme de communication en termes d'imprégnation. D'un côté, il y a les corps d'État qui ont été régentés dans une forme de communication institutionnelle, et de l'autre côté, il y a d'autres corps hiérarchisés organisés dans l'intermédiation sociale, et tout ceci mis ensemble à rassurer l'information sur les finalités que contiennent la nouvelle loi sur l'identification. Et une fois ceci opéré, ça nous a permis de lancer l'opération elle-même, qui est le recensement administratif à vocation d'identification de la population, qui a duré 6 mois, et au terme de 6 mois, ce qui a garanti, ce qui a prouvé le succès des opérations préalables en termes de sensibilisation, en termes de participation, c'est le résultat obtenu à la fin, qui est 95% de la population béninoise enregistrée dans une phase initiale de 6 mois. Et ceci a permis de mettre en place le registre national de la population, qui a permis aujourd'hui d'impulser la nouvelle réforme en termes d'usage, en termes d'utilisation de l'identifiant unique. Merci.
Merci beaucoup, Jean. À ce point-là, at this moment now, I think it's probably best to open up to the panel to discuss, bearing in mind that this is a space on the legal framework. I think it's interesting to see the progression from where we started with an enabling space. We had a service we wanted provided. As a result, we needed, because we wanted to be universal in our first speakers, a unique identifier through safeguards to sensitization of the population and a larger legal reform that in turn needed to be presented to the population. So I think the underlying question that perhaps we open with, and we can tailor it accordingly to the groups, is, well, what legal reform is the most helpful? What was the most significant impediment? Is there something that you jump on? We've heard different perspectives on the legal piece, so I'll open it up, and now you can moderate better from that side, who's asking to come in, and I'll try from this side. And we'll try to get it fluid amongst the panelists before opening it up to the audience. Thanks. Who would like to step up first, looking at that larger question of legal spaces?
I think from a Kenyan experience, the most fundamental legal reform was putting in place the Data Protection Act. And
Before
also,
or in parallel to the digital ID system?
it was before parallel, I would say so, because they are happening at the same time. And also changing the digital ID. Sorry?
I don't know how the audience is hearing, but it's actually very difficult to hear on this side.
Oh,
If
okay.
you can speak forward towards the audience, I think that might help us.
Yeah.
Even if that's slightly rude, our apologies.
Okay. I think one of the court was very categorical that before you can embark on the digital ID, you need to have a Data Protection Authority. That is one of the findings of the court. And I think that is what then propelled the next level in as far as digital ID is concerned. Okay.
Thank you.
In our case in Nigeria, we had the NIPSI Act as far back as 2007. That's the National Identity Management Act. However, with the new digital ID, there was supposed to be some support from some development partners, and a major condition precedent to the support was the data protection law for the country, and also to have an independent data protection authority. So in our case, the Digital Identity Management Commission and the Data Protection Commission, eventually we do have any choice than to work together, because our law will lead to support that the Identity Management Commission is expecting from development partners. And to a large extent, that has really assisted us as a country, because you have two major government organizations pursuing the same law. So they will speak to their stakeholders, who will speak to our own stakeholders. So to a large extent, it assisted us, and even as we speak, they are now trying to amend the law, the identity law that was passed in 2007, now to really reflect the actual digital identity they were talking about. So the only major impediment that we had was on the part of the stakeholders, the citizens themselves, to really understand what we are trying to do with the law. Some still see it as, it's my own identity, what's your business in protecting it on my behalf? And that was a major challenge for us. But because we deployed the strategy of actually involving all the stakeholders from the beginning, eventually we were able to address that. Now, when the law has been passed, the next stage of implementation also, we need to really work seriously on awareness, which we believe. And one thing that we also work for the law is that if there is any conflict between the data protection law and any other law in the country in the area of data privacy and protection, our own data protection law prevails. Thank you.
Thank you, Dr. Vincent. May I, Laura, you have the mic. I just wanted to see if, okay.
And we have 15 minutes left, so if everyone can keep their answers on the briefer side, please.
Yes, sir. Can you hear me? Okay. No, I wanted to add also, in terms of priority legal reforms, I think there's also a point around clarity and harmonization across relevant legal frameworks. When it, and this really depends on the process, how the reforms are introduced under a standalone law versus amendments to existing acts. Definitions can lead to sort of cloudy understanding and interpretation and vagueness. So I think that is a really key issue to address as reforms are being undertaken. And then when they are, sometimes a lot is left to the regulatory frameworks that will be adopted afterwards. And so big open questions about things like disclosures, access to administrative review of decisions, things like that are really going to be key for safeguards, are kind of hard to interpret in the parent legislation.
Anyone from this side on the order of priorities in terms of legal reforms? Who would like to start? Josephine. Okay, there you go. I'll give you the mic here.
Oui, je pense qu'au niveau de la Côte d'Ivoire, notamment pour la couverture maladie universelle, on ne pourrait pas parler de difficultés pour la gestion des données à caractère personnel, puisqu'on arrive après que la loi soit prise. La loi elle a été prise en 2013. Et la loi sur la gestion des données à caractère personnel et la loi sur la CMU arrive après, en 2014. Après, c'est l'application de ce mécanisme qui est mis à la disposition de l'organe qui gère la couverture maladie universelle. Là, effectivement, il y a parfois des difficultés, mais on arrive dans un contexte où on a déjà des dispositions juridiques qui sont là. Voilà. Merci.
Merci beaucoup.
So in Rwanda, when we were amending the law on the issuance of digital identity, we had already the law on the protection of personal data, and it came into force actually last year. So everything that we did, we had to adhere to the law on the protection of personal data.
Yeah, thank you. In Tanzania, to have the environment which enable the digital ID, we have enacted e-Government Act 2019. We have also Electronic Transaction Act of 2015 and the Data Protection Act of 2022. But after Data Protection Act, we established the office, the Commission of Data Protection, which oversees the implementation and safeguarding of the personal data information. But all this was possible because of a good political will and the government commitment, as well as using agile methodology to start small, but having a bigger picture of digital transformation. Thank you.
Thank you. Anyone else on this question, or should we?
I think we move on to the next question. Do you want to choose one now, or?
I guess we have 15 likes over the one on GDPR. And I think it's a very good one, and it was one of the questions that I would have asked Laura also to comment on. So maybe I'll start with you, and I'll open it up for the rest of the panelists. So GDPR is for a developed nation with a mature digital infrastructure. Will GDPR rules affect the time of development for African nations? Can we, I guess the question, if I'm understanding it correctly, is there a one-size-fits-all approach? How can we apply global norms that are not necessarily adapted to the level of maturity of the context in which we are launching digital IT systems? Laura, I'll start with you.
I can start, right, and you know, in a very lawyerly answer, I guess it depends. But I think where there are GDPR provisions are written into a lot of the laws that we've been talking about already. So they're here in a sense. And so, I mean, I guess what I would say, no, it's not. I mean, I think a carbon copy importation into a context that has had nothing to do with the development of those rules, and you know, sort of I think that is the wrong approach, and I don't think that I'll find a lot of disagreement with that in this room. But what I do think is helpful, for instance, where we have a provision that requires a data protection impact assessment, for instance, to look at what standards have been developed in order to conduct a data protection impact assessment, to survey those, to when the Data Protection Authority is issuing regulations under its native act, you know, referencing those standards and borrowing. I think where that is useful and explainable and understandable and contextualized, you know, I would endorse that approach. And I think there are standards coming out of the bodies that are directly charged with interpreting the GDPR at the EU level or at the national level. Those are really useful. There's some, you know, court decisions on whether individual impact assessments meet those standards. Those are really helpful just factually to borrow from, but are they precedent for a country, you know, a country that has a similar law? No. I mean, I think that's, I think that's the approach. These are persuasive authorities. They're very useful. They shouldn't be rejected because they come from another jurisdiction, but they also shouldn't be imposed.
I guess a follow-up question on this one, and maybe you can also, both commissioners, comment on it, is perhaps what affects the way GDPR-like regulations might be applied or not in certain national contexts is the country ready for an accountability, risk-based approach, data protection compliance, or do we have to go through the pre-GDPR experience of authorizations, declarations that are made? And it's a different regime approach, and I guess maybe if you can comment on that.
I want to say, sorry, Vincent. I want to say it cannot be one size fits all. In our case, whereas many countries developing data protection acts tend to benchmark on GDPR, there are different nuances that are different when it comes to the African context. And I couldn't agree more on what has been said, that you need to be specific to your country. And let's say this. We are in an era where e-commerce transcends boundaries. And therefore, we can't wish away tools that are being developed elsewhere in the world. We can borrow, we can share, we can collaborate. And besides GDPR, there are many other tools being discussed across the globe, in the global Pacific, Asian Pacific, in the Americans, tools that are possible in as far as data protection. Of importance, I say, the underlying issue, your true north, as a governance, as an ID institution, as a data protection authority, your true north is the right of the data subject. What did the data protection come to address? Fundamentally, it's about the right to privacy, that you can no longer subject my information to surveillance, and you can no longer use my information unvetted for anything that you wish. I own the information, and therefore you need to hold me accountable. So once we understand that, it won't matter which tool we are talking about. In our case, what we have done, we've gone beyond discussing the data protection impact assessment, and we've issued a guidance note. That is one of the 8 we have issued, so that it is relevant and specific to the Kenyan context. Our guidance notes on how to conduct a data protection impact assessment is available on our website. It helps a guide for data protection authorities in the room that would like to appreciate and actually understand what goes into it. So there's no one size fits all, but fundamentally, what are the rights of the data subject?
Thank you so much. Conrad, how do you want to do this?
I think Thulani would care to add into that question, so thank you, and thank you for the responses.
Yes, just maybe to add on that, in terms of, South Africa has actually gone even beyond by creating a new data protection law, which is the Protection of Personal Information Act, where it actually goes beyond just GDPR, because what it does is also involves protection of information of people living, not only living individuals, because with GDPR we're looking at living individuals, but this one transcends beyond even people who have passed on. But also the issue of e-commerce transcends, it does not also locate or applies in a particular space. It says, across boundaries, as long as the information is collected of a South African citizen, has got to be protected, whether you are transacting on e-commerce on any other platforms. Thank you very much.
Thank you. And we'll just ask you to be brief, Vincent, because we'll take one more question and try to get the panel to go with it.
Okay, I can't agree less with Immaculate on the fact that there's no one size fits all, but we must really look at ourselves as a continent, our culture, our level of digital literacy, our level of deployment of digital technologies for us to really look at what works for us. However, in terms of the principles of data protection, the rights of data subjects, the basis for even processing this data, there is no point in reinventing the wheel. All you need to do is look at what has happened and look at what happens, or our own situation in our own continent. You mentioned the issue of cross-border privacy rules. What are we doing in Africa as a continent to look at what really works for us as a continent? These are issues that we need to really evaluate and know if some of the principles will work for us or not. For instance, in Nigeria, when we were working on our law, the first part of it, which was regulation, we didn't include legitimate interest. Because we keep asking, legitimate interest on whose interest? Is it on the interest of data subjects or data controllers and processors? However, in the law, we did, with a caveat, that whatever we want to do under legitimate interest must not override the original rights of the data subjects that have been listed. So it's a thing, even at the level of EU, there are still disagreements of decisions. The last decision against Meta about 8 countries did not agree with the decisions of the Council of Europe. So different countries, different level of development, different culture, different principles, and that is what we should pick up from Africa.
Thank you so much.
Thanks. I think we'll just take one more. We're running short of time. We'll beg your indulgence for just a few more minutes to give the second question a little more time. The next highest one selected is, aren't, quote, stable, end quote, unique identifiers potentially more harmful than biometric data, which are not even secret stricto sensu? I'd like to shift it slightly, since we spent such time on data protection, shift it outwards to 2 things. One, understandings of what biometric data is, so engagement with the population. Maybe that involves a consent element, but in any case, making people understand what you have and what you're doing. So focus on that piece more so than the technical piece of which is safer or not. And then reciprocally on the other end of the room, where we started off with, we have a service we want to provide, we're going to roll out a unique identifier, probably going to link it to biometrics or some sort there. What are the complications that in moving from that functional space, universal health coverage or otherwise, healthcare, to making that a larger base? What concerns might that elicit? So rather than strictly speaking, which is the more dangerous, how are we creating systems that the populations understand and moving from functional to mitigating those risks that are presented with these systems? Thank you. Whomever would like to speak up first.
Thank you. So I think on the data set to be collected, and also to ensure that we mitigate any reason for keeping or of discriminating or not having everybody onboarded, is by extending the biometric collected, we ensure that those who do not have one type of biometric, if you have multiple biometrics, it reduces the issues of discriminating those who do not have those specific, because if you have only single one as a sort of identifier or to deduplicate, then when they don't have that specific one, it becomes hard to onboard them. The other one is, I think also there was a question for like somebody who do not have like a breeder document or prerequisite to be onboarded, and to see how to ensure that they are also part of this digital identity journey. So in Rwanda, we looked at, in our law now, we have the provision of an introducer, and an introducer is somebody who knows that person who, for many reasons in our communities, we might have somebody whose background or parents did not take that initiative of registering them, but they are known within the community. So there is somebody within the community who's already identified, who knows that person, they can vouch on their behalf, and then they can onboard them. So those are measures that we're looking at to ensure that we do not discriminate in any way, and we ensure that everybody has an equal access to such a platform.
Thank you. Just to add on top of what Josephine has said, in Tanzania, we have don't want to leave anyone behind. So we have, from the design of the national ID, we know that there is a challenge of having the identification document. So we designed a special form for those who don't have birth certificate, passport. They fill this form, and this form is authenticated by the local government authorities. So this becomes as a basis for the to register those who don't have formal document. And in and the issue of the biometric, we know the core biometric system which is used in national ID systems is fingerprint, and you know there are some limitation of the fingerprint, limitation of age, limitation of some diseases, limitation of age. So we are trying to include as many biometric engine as possible. We are trying to introduce a so-called API system, which will have the fingerprint, iris, and facial. This to make sure we include everybody in the national ID and to have the universal national ID coverage. Thank you.
Yeah, let's keep with that side and move this way.
Merci. Au niveau de la Côte d'Ivoire, effectivement, pour éviter toute exclusion des personnes qui vivent sur le territoire, déjà, l'enrôlement, il est gratuit. Donc l'État, affirmant sa ferme volonté de permettre à toutes les populations d'avoir accès à ces prestations-là, à payer l'enrôlement à la CMU à travers au démarrage et à travers un contrat de partenariat public-privé. Donc c'est gratuit, toutes les personnes peuvent se faire enrôler. Ensuite, on a été confronté à la difficulté pour des personnes de fournir des documents qu'on demandait au départ. Au départ, on demandait à la fois la CNI et l'extrait d'acte de naissance. Et on s'est rendu compte dans nos campagnes qu'effectivement, les personnes n'avaient pas ces documents. Et le processus a évolué en 2022. Il y a un arrêté qui a été pris pour que toutes les personnes qui n'ont pas ces documents-là puissent se faire enrôler. À partir du moment où on prend pendant la collecte les empreintes, et ce sont ces empreintes qui sont vérifiées au moment de l'accès à la prestation. Donc cette identification nous permet aujourd'hui d'aller vers toutes les populations. Et on a un autre problème, ce sont ces personnes-là qui n'ont pas d'empreinte effectivement dans nos contrées, parfois pour certains qui mènent certaines activités, ils n'ont pas d'empreinte. Et aujourd'hui, le dispositif a évolué. Depuis l'année dernière, on a un nouveau dispositif qui permet de faire l'enrôlement et la production des cartes sur place. Et dans ce dispositif, il est prévu la collecte de l'iris, justement pour réduire le nombre de personnes pour qui on n'arrive pas à avoir des informations biométriques, notamment les doigts, parce qu'à la fin, il faut qu'on contrôle, il faut qu'on sache que la carte qui est en face dans l'hôpital appartient à la personne qui est effectivement à l'hôpital. Voilà, merci.
Let's briefly do Laura and Jean, but very briefly so we can get everybody just 30 seconds to wrap up, please. We're 4 minutes over.
Merci.
Please give us 3 more minutes.
Je peux?
Allez-y.
Si.
Merci. C'est à l'appui de tout ce qui a été dit, je dois seulement demander que pour ces genres d'opérations, effectivement, il faut tenir compte de l'inclusion dans une approche intégrale, et il faut surtout éviter de confondre l'opération du recensement qui vise à attribuer l'identifiant unique aux opérations d'attribution de citoyenneté. Et en faisant la démarcation entre les deux, vous assurez un succès à l'opération. Merci.
I can't resist answering part of that question that's about sort of the risks of profiling using the unique identifier, and just to emphasize that, you know, one thing that I think has been great about this forum is to learn about some of the tools that won't allow for that. And since the idea really is to build trust and to allay some fears that, you know, a biometric-based system or not, but something that could be used to link someone and track their activities when they're transacting or receiving payments, you know, that we don't actually need to design systems that way. I think really paying attention to the emerging technologies and the fact that that is possible, and figuring out how it actually, if it can and how it can be incorporated into these systems is really key.
That's great. Thank you, Laura. Great words of warning and great way to say how we adapt the text. Maybe we start with just 30 seconds. Each person give their last takeaway, and that will take us 10 minutes over. And we'll start with Côte d'Ivoire and Madame Bamba, please.
Merci. Dis juste que pour des mécanismes tels que les nôtres, où l'identification se fait pour avoir accès à une prestation, il faut qu'au bout, on ait la prestation. Et aujourd'hui, on s'attelle effectivement pour que la prestation soit au bout, pour faciliter le dispositif qui est en train de se déployer à l'endroit de toutes les populations, parce que nous, on s'est fixé pour cette année d'atteindre 20 millions d'enrôlés, et l'année prochaine, atteindre les 80%. En Côte d'Ivoire, on est 3 millions de personnes. Donc voilà, merci à tous.
I think when implementing such a project is to ensure that we have collaborative approach with inclusive involvement of all the stakeholders in the ecosystem, because the identity ultimately is to be used for something, so we ensure that there's no blockage to onboard, but also to the usage.
Thank you. To have a proper and robust system, we need to have stakeholders engagement. and put people at the center of any issue and any design. And also work closer with all stakeholders, including development partners, to make sure that you have a robust system which can be used by other stakeholders, especially other sectors, to solve the identity challenge. This is the key because now the national ID is the center of everything. Thank you.
Just to emphasize, the reason we have data protection authorities globally, or in Africa in specific, is the importance of trust. And the beauty of how most of the data protection authorities are actually structured is on self-regulation and the rights of the data subject. Let us build this journey on e-commerce, the trust and rights of the individual data subjects, so that we make this ecosystem more trustworthy. It will take collaborative effort from civil society, data protection authority, judiciary, ID institutions to build the ecosystem. It's not a one-size-fits-all, it's one of the issues that requires collaboration.
Mine just to echo the issue around inclusivity. In terms of implementing digitality in all countries, let's involve all stakeholders, the public sector and private sector. In addition to that, how about those Africans who live in rural communities, who don't know how to read and write, who are not captured yet? How do we ensure that they are captured? We need to deploy appropriate strategies to ensure that these people are appropriately captured in whatever we are doing, which I think is really important to all of us. Thank you.
I think my closing point would just be, to bring the same level of investment and innovation and sort of entrepreneurial drive to thinking about the safeguards mechanisms that line up with data protection, with identity, freedom of information, access to justice, access to legal aid. There are innovative tools that leverage technology in those spaces as well, and they can be part of this ecosystem-wide collaboration.
Perfect. No, thank you very much. I think for all of us who have made contribution here, I think the theme is around ensuring access, inclusivity, but that can only be achieved if all governments and together with the private sector are investing in IT infrastructure. Because without proper IT infrastructure, there's nothing else we can do. You need to have what we call safe space to save data, like the cloud and other spaces, but it needs us to invest. Otherwise, it will not come for free. Thank you.
Merci. À l'issue de toute cette discussion, moi, je dois compléter simplement qu'il fallait, à l'égard de toutes les initiatives qui émergent en termes d'enregistrement, en termes d'attribution de l'identifiant unique, le prochain défi pour nos États, en termes d'intégration régionale, ça serait le défi de l'interopérabilité. Merci.
Merci. Merci à vous tous. Thank you. It's been a pleasure. We have kept you 11 minutes over. We apologize, but I hope you found it worthwhile. Thank you.
Thank you. Thank you. It was a great session.
A pleasure.
Yes.
Pleasure.
Yes.
Quick reminders, mesdames et messieurs les honorables députés et membres du Parlement, all members of Parliament, honorable members of Parliament, and representatives of the Senate, we plead your indulgence to stay with us because we'll be going to the third floor as planned for your dinner. And of course, we plead with you all to leave your headsets with us in the hall, and if at all you you forgot yours or what you used in your rooms, make sure you bring them back to us tomorrow. Tomorrow we would resume at 8:30 in the morning. Mesdames et messieurs les honorables membres du Parlement et du Sénat, nous avons un dîner parlementaire dans quelques minutes. Ça sera au 3e étage. Merci. Merci. Et rappelle aussi à tous ces membres, ces ambassadeurs de ID for Africa, ambassadors who belong to delegations concerned with the dinner upstairs, do stay with us. Thank you. Headsets. Remember to keep your headsets, please. And if you have any you forgot in your rooms, please bring them back to us tomorrow. Thank you. All our special guests, remember to be part of the dinner. Thank you.